All rise. The Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. Welcome. This is Arizona Court of Appeals, CV120798, in regards to the marriage of Helen Chang and William Sue. Did I say that correctly? Okay. I hate when people mispronounce my name, so. Anyway, welcome. This is for council's information. These proceedings are being recorded. They are being recorded both audioly and visually. Hopefully in a couple of weeks, if the equipment all works well, you'll be able to see yourself on YouTube and tell all your friends and family. We've also conferenced the case this morning. We've read the briefs, looked at relevant portions of the record, and so as you're going through your argument, keep that in mind. The podium up front indicates that each of you has 20 minutes to present your argument. Appellant, you may reserve a portion of your time for a rebuttal. If you'll tell us when you first come up how much time you want to reserve, we'll keep that in mind and try not to horn in on your time. And as you approach the podium, please state your name and who you are representing. So with that in mind, you may begin.
Good morning, Your Honors. My name is Phil Gerard. I represent Bill Sue, who's the appellant. With me is Bill Begley, who worked on the brief, and in the back is Annette Burns, who also was co-counsel at the time of trial and has worked on the brief. The legal issues obviously have been thoroughly briefed in this case. The standard of review, I think, is really not an issue, and there is very little that I want to say about the jurisdiction issue unless Your Honors have some questions. Basically, this was the Dickert deal. The pretrial order specifically preserved each party's right to have an appeal, and anything that is as restricted as wife is now arguing would simply be superfluous because that appeal would have always been permitted. So again.
Well, let's talk about that.
Okay.
The
I guess that tells me how much I do or don't want to reserve in my time.
The agreement preserved, expressly preserved, a right of appeal to this court, and expressly said, no, the parties need not file a motion to vacate in the trial court. Setting aside the exclusion of the trial court from the process, a party aggrieved by a judgment that adopts an arbitrator's decision may always have a right of appeal to this court. So how are we to infer from the language simply granting a right of appeal to this court that we have some powers of review that the statute, which the agreement expressly incorporated, doesn't grant?
I suppose there's at least three answers to that. One is the conduct of the parties and what they intended. Keep in mind that when this stipulation was entered into, that the parties already had the pretrial or the preliminary report from the jointly retained expert who had identified that of this approximately $22 million, and I'm going to leave aside the retirement account issues that were eventually settled, but of the $19 million in brokerage accounts, that there was $5 million that was community, and of course a portion of that was separate and a portion was community. So the parties already knew what was the basic issues in this case, and to have not understood that there was going to be issues of first impression or certainly substantial legal issues would have been totally inconsistent with everybody's mindset at the time. If the joint report had been approved by the court, we can certainly understand that wife would have been standing here appealing, and the only difference would have been that Bill Sue wouldn't have been claiming what wife is now claiming, that this is somehow a restricted appeal. So the conduct of the parties, not only when they were going into the stipulation, but all of the conduct during the course of the proceeding, where there's multiple references to trial.
Well, it was a trial.
Right.
It was much more of a trial than your clients would have received in our crowded Maricopa County family courts right now. But given that the agreement incorporated ARS 12-3000 et sec, how are we to infer that it incorporated an it constituted an agreement that would grant this court more powers on review than the statute allows?
Well, I'm not sure if you're suggesting that somehow we've created an additional right under the arbitration statute. This is a hybrid. That was the second part of my. None of you have been fortunate enough to be Superior Court judges in Maricopa County with family law cases. So, I don't think. So this is the reality of family law trials in Arizona now in this county, where there's any complexity to the case. This is a combination of the Rule 72 special master and the private judging world. And that was, so the whole reference to the fact that there would be no appeal taken to the Superior Court of Arizona was simply the elimination of the second go-around that exists with respect to Rule 72 of the family law rules, where after you have some private judge dealing with these issues, then you can go back to the Superior Court and deal with that issue. I think the third part of the answer is the issues that we've already also briefed, which are the courts in this country, the two most significant being the California and the Texas Supreme Courts, that have obviously said you can do exactly what's happened in this case. And you have to then give under all the contract principles, because this court has repeatedly said that arbitration is about contract. Well, contracts have to be interpreted to be meaningful, and all parts of it have to be interpreted to be meaningful.
That's the interesting thing about this case. The cases that emphasize that arbitration is a creature of contract emphasize that we are eager to recognize a contract by which parties agree to resolve their cases quickly and with a minimum of expense. But this contract was a contract to resolve a dispute with not quickly and not cheaply, which is fine. You know, parties can agree to do that. But getting back to the California and again the Texas cases that have recognized the right of parties to agree that the Court of Appeals may exercise a more substantive review of an arbitrator's decision, those cases, it seems to me, the agreements in those cases are far more precise than what we have here. The California case, I have it here, cable
connection, yes.
I mean, there the agreement said the arbitrators must follow the law, and if they don't, their decision may be reviewed on appeal.
Well, we have the same thing here. That's the second part of this whole issue, and I guess we are going to take most of our time talking about this. The arbitrator was supposed to decide this case according to Title 25. Obviously, he didn't. In other words, that's what all the merits part of this appeal is about. So when you give authority to an arbiter to decide a case under certain limitations and they don't do that, then they've exceeded their authority, which is another basis where this court is supposed to then remedy those failures to follow the law. It's in excess of their authority. But, again, it's a function of contract principles where if this court is going to, the RUAA, Arizona's, the Revised Uniform Arbitration Act, has not dealt with this issue in Arizona. So it's obviously a first issue to this court. So I don't know whether if you're going to decide that you can't do this no matter how precise the language may be, then the language in this stipulated order won't matter.
Right.
If you're going to decide that you can do it, then the language in this order is going to be good enough. You may tell us, in the litigants in this state, okay, you need to be even more precise. You need to, say many magic words. But this time, with no guidance from this court and with the conduct of the parties, it's inconceivable that the parties didn't think they were preserving a merits appeal in order to protect against the failure of the arbiter to decide the case consistent with Arizona law. Are we,
I understand your point.
okay, thank you. Nobody else has any questions about that?
Not at the moment.
Well, the first 2 minutes that I was going to spend about talking about that are now turned into more than that. In any event, let me then try to move ahead to the rest of the case, because you have the merits of this case, and as we've said, there's really two simple issues in this case. I suppose I'm told that, or at least I seem to remember that one of our presidents once said there will be, during one of the debates, that there would be no math on the test. Well, this math is obviously pretty easy, so that's the simple part of this. I'm going to ask Bill to turn this thing around. Because the first part, of course, is the Intel shares that are in the account. And hopefully all of this has been clearly set out in the many details that we put in the brief. The simple background of this case is that all of the records exist, all of the transactions that were putting any of the community funds into Mr. Sue's brokerage account are all identified. This case is obviously unique in the sense that, and we've pointed out that Brebaugh hadn't even been decided until 2005. The parties were living in China at the time, so there would have required more than clairvoyance, I think, to figure out how to deal with these issues. So the Intel shares is the simplest part, obviously. He owned over 400,000. I can give you precise numbers if you want. They're in the briefs, but in order to talk about it easily, I think he owned hundreds of thousands of Intel shares before he got married. He had hundreds of thousands of additional fully vested options with respect to Intel shares. By the end, and no Intel shares are ever acquired during the marriage other than the 5,440 that are community. Nobody contends that there was ever any community Intel shares other than at most 5,440. At one point, Judge Budoff even said, why don't you just leave that out of your questions as the exception? Because to me it would have been de minimis, but one never knows how you're trying to preserve a record. So this is the simple math. At the end of the marriage, there's 2,770 shares in the Merrill Lynch account, in the brokerage account. The most that ever was community was 5,440, but it's undisputed that 999 of those were sold. So the 4,441 subtracted from the 207,770 leaves us with the 203,329. Now, for the rest of this argument, I'm probably going to talk about 200,000 instead of the specific number. What's the 24,589 about? That's the issue that, of course, complicated the presentation of this case, because the jointly retained expert is not a lawyer. He got the legal issue wrong. Unfortunately, the arbitrator followed his lead and never even addressed the issue. That's the simple issue of what is the effect of Potoff on fully vested options. Potoff says that when you acquire the right to something, it is your separate property if you've acquired that right before marriage. Even the case that they most want to talk about, Shue versus Rose, which is a Washington case, which is distinguishable in the facts from the conclusion, but it says also that when you have a vested right that's been granted before marriage, it's your separate property. And of course, the California Supreme Court is now, as we've explained in our reply brief, because timing was wonderful, in the Green case, taken on yet another issue, which is the purchase of additional rights under a retirement thing for military service, and said that that right, because it had been created before marriage, is also separate property. So all of the Intel shares, other than at most the 4,441, and in this instance we're giving the community the benefit of the doubt. The community expense doctrine or any other set of reasonable assumptions would have simply caused the court to reasonably conclude that those were already gone. I mean, as one example, there was over $200,000 put in the children's 529 accounts. There was 100,000 Intel shares put in the CR2, a charitable remainder trust that had been created by Mr. Sue. And so all of these things would have been community expenses that would have wiped out any limited community Intel shares. So then let's turn to the rest of the case, because what do you have after you decide that the Intel shares are all husband separate property? Because keep in mind that on any given day the price is somewhat different, but the easy math is $20 a share. That's over $4 million, and it was equally divided with wife. So then what's the rest of the case about? Well, like all problems. If you miss the first step, you're probably going to fall down and miss the rest of the steps. And so they never got the first step right. So now you only have to, on remand, have the court determine or confirm that the $203,000 at least are his separate property, and then talk about tracing. Tracing is an interesting issue in this state. The case law is sparse, almost all of it before the joint management of the community, and even since, consists of cash in accounts. There's one exception, the Everson case, which I don't think we cited, which deals with stock in a corporation, which was reversed because the trial court had found that it was all community, and of course the court found that some portion of it was separate. So when you have things that are distinguishable, Intel shares, investments in brokerage accounts, obviously these things can all be traced. So what does explicit tracing mean? Nobody has defined that. It's certainly not dollar for dollar. It's certainly not connect the dot, which are the words that the arbitrator used. It's certainly not blue nickel, which is what wife's advocate argued at the time of the arbitration. It's simply a function of reasonable deductions. Now, Title 14 has given us plenty of guidance. And Stevenson, our Supreme Court, referred to the predecessor to that statute and said that it was the basis for concluding that the O'Hare decision was right, even though the statute was passed in the interim. And the Batiste case comes along and says something as simple as when you put monies even in a joint account in proportion, then we're going to determine that that's what's going on. So for them to argue that percentages have no role, proportionate has no role, fairness has no role, this is what happens when you have a party submit findings and they're adopted verbatim by a court. Long ago in the Elliott case, this court basically said, trial courts should be careful when they're crafting findings. Don't just basically mimic, my word, what the parties are telling you. So when somebody says that there's no room in Arizona for fairness or pro rata or proportionate division of assets, that's simply inconsistent with the law. I'm down to my 4 minutes, unless you have any questions about the merits of this case. Let me see what they've got to say. Thank you.
Thank you, counsel.
One more thing. Good morning, Your Honors, and may it please the Court. My name is Scott Boehm. I am appellate counsel for wife Helen Chang. Trial counsel Tracy Gordon is with me at the table over here. At the risk of getting a bit ahead of myself, because I do want to talk about what Johnson talked to Phil about, this whole thing was never mentioned at the arbitration. This was presented in their motion to vacate after the arbitration. So, and in fact, this bit up here about the options, Reinmuth, their own guy, said it was community. And they came up with this theory after the fact. So I think it's too late. Under the Nolan case, Judge Johnson signed off on. You can't seek to get an arbitration award set aside based on something that was dreamed up after the arbitration. So I think they have, if we ever get to the merits, they've got that problem. But more importantly, I'd like to talk initially, unlike the appellant, about the standard of review. We're here on seeking a confirmation of the trial court's confirmation consistent with the arbitration agreement, and we're asking you to affirm that. The nutshell of our position is covered by the Hurt v. Harvey case from this court in 1978. I'll read it to you quickly here. Our case law makes it clear that an arbitration award is not subject to attack merely because one party believes that the arbitrator erred with respect to factual determinations or legal interpretations. Apart from questions of fraud or corruption, the decisions of the arbitrators on fact and questions of law are final and conclusive, except when they conflict with the express guidelines or standards set forth adopted in the arbitration agreement. That's our position in a nutshell. That was decided in 78. Subsequently, 2011, the Nolan case, as I mentioned, Judge Johnson was on that case. So you've been on a bunch of these cases. You probably know more about this area of the law than anybody in the state, so I feel a little bit inadequate preaching to you about it. But it was also affirmed last year in Atrius, which I cited, starting on page 1 of my brief, because the question is not so much, do you get to go straight to the Court of Appeals, which is what was covered in the agreement, but what happens when we get here? Because in Atrius and in Nolan and all the MDs out there that I can't talk about, obviously, they all got to go to the Court of Appeals. The question is, what happens when we get here? And as Hurt pointed out, and has been followed through subsequently, it doesn't matter if the arbitrator was right or wrong, because that's what binding arbitration means. You pays your money, you takes your chances, and you're stuck with it.
Well, Mr. Boehm, Mr. Gerard argues that the arbitrator in this case, by failing to either appreciate this argument or resolve it, exceeded his authority, and therefore that's an allowable basis for this court to examine that.
Yeah, two cases have rejected that theory. One, the Smitty's case, and the second one, the Atrius case. And both of them say that let me back up a little bit. Their argument that they're exceeding their authority, that the arbitrator exceeded his authority, was not raised until the reply brief, because they didn't want to talk about the standard of review and the contract and the specific language of the contract in their opening brief. I'm the one that raised my hand in the answering brief. So in their reply brief, for the first time, in order to get around the pretty big problem, they made the argument that he exceeded his authority. But if you look at the basis for which they argue that Judge Budoff theoretically exceeded his authority, it's that he committed legal errors. They're taking these same legal errors, most of which were not presented to the arbitrator at the time, and now instead of saying they're legal errors or factual errors, they're excessive authority. And as Hurt discussed, and also the Smitty's case, it's not whether the court erred legally or made factual mistakes, it's whether he exceeded his powers under the arbitration agreement.
Do you think the parties in Arizona could, under the law, craft an arbitration agreement that would agree to have the Court of Appeals do a merit review?
No, and I'll tell you why. I was prepared to come down here and concede that was theoretically possible under the revised statute, but then I thought maybe I should read the darn thing. And if you look at ARS section 12-3004, subsection C, this is under the heading, and this was not contained in the original arbitration agreement. And before I forget, I will point out now, this has not been adopted in either Texas or California. So I think, as you pointed out, Judge, even those states require very clear, specific language retaining jurisdiction to avoid errors. But if you look at this new statute, 12-3004, it's titled Non-Waivable Provisions, and subsection C says, a party to an agreement to arbitrate or to an arbitration proceeding may not waive, or the parties may not vary the effect of the requirements of this section and in a litany of other sections, among which is 12-3023, which is the provision vacating the award. So although before I read this darn thing, I thought, well, maybe they could theoretically, because it is a matter of a contract, and Snowberger said that way back when. I don't think you get to do that now. So even if the parties had made a more specific provision in this case, I think it would be violation of that provision of the statute. And, I don't know that the court necessarily needs to get there, because it all kind of comes back to the language. And, Phil talked about this language. It just says that you don't have to go to the trial court to seek review first. You just get to come to the Court of Appeals. That's fine. Here we are. What do we do now? And that's where all of the cases on the applicable standard of review come in. So all of their merits arguments, I don't think the court even needs to get them. I think we win on the merits. I talked Bill, I was blue in the face in the brief on the merits. But I don't think the court even needs to get to the merits, because if you just look at the language of the agreement and the statute that I found while I was preparing for this argument, they lose on this 6 ways come Sunday. So even if there were errors, that's what binding arbitration means. And the idea that this was a longer trial than they would have gotten in Superior Court, and the fact that the arbitrator, former Judge Budoff, did detailed findings of fact in the nature of that a trial court would do. So what? I mean, that doesn't affect the standard of review. The revised act specifically requires the arbitrators to make a record of their ruling, and just because he or she makes a good record of their ruling, that doesn't take it outside of the provisions. I started talking about this a little bit. Their contention in the reply brief that the arbitrators now exceeded his powers because of the legal errors. If you look at the alleged legal errors that they're making, the starting point has to be Porter and Cooper, the 2 Supreme Court cases on explicit tracing. And what they're arguing here, if you ever get to the merits, is that the arbitrator erred by following Supreme Court law. I mean, they couldn't be more clear. Porter in 48, Cooper, Judge Gordon quite a bit later, and this court has followed it in the Roe case. It was Judge Hathaway down in Division 2, but nonetheless, says you have to have clear and convincing evidence of explicit tracing. And they don't have that here. And we'll get to the facts in a minute. But what their theoretical argument is, that the former trial court, the arbitrator, erred as a matter of law by doing what Porter and Cooper said he had to do. Even Reinmuth says, and I can't explicitly trace here, that's why I got to come up with this theory. The facts support him. All of these facts on commingling, and this at bottom all the way up is a commingling case. We're not talking about what Bill Sue had initially, what Reinmuth did as far as the allocations go initially. We accepted all those as givens. This is pure and simply a commingling case. And for 11 years and 3 months of their marriage, this husband, 25,000 separate commingled transactions. The primary account was opened with 2,000 shares of community assets. Everything after that was added in, commingled, mixing, the various words that the courts have used in these cases. So from the get-go, every one of these 24,999, excluding the initial one, everything after that was commingled. And it was moving stuff here, moving into the 10 sub-accounts, consolidating into 3, putting some over into the collateral accounts, selling some, using some for household expenses. It was like the 3-card Monty trying to follow these around, which Laura Lepardi said, you can't do it. Reinmuth, to his credit, says, you really can't do it. That's why I came up with this ratio and methodology. And Mr. Gerard can argue all day about this explicit tracing idea was back in the old days when we were just talking about money and where things are more sophisticated now. So you can't trace it. Well, that's what the law requires. And the arbitrator was stuck with it. And with all due respect, you're kind of stuck with it too, because it's the Supreme Court's the one that said it. And they just don't have it there. So I think that's, on the merits, kind of the starting and ending point. The trial court here, or the arbitrator, excuse me, did a very detailed findings of fact on this. Yes, they were prepared by our side. They prepared their side too, but they were annotated with specific citations to the transcript. The question ultimately, whether something is community or separate in terms of commingling, is based upon the facts of each case. And the arbitrator, excuse me for calling Judge Budoff the judge here, he went through this very, very specifically from pages 4 to 19 of the findings and went through and said every place that Rymuth said can't be traced, can't connect the dots. We don't, once these 25,000 transactions started going, we can't figure out where they ended up. And under the law of the Supreme Court law, Porter and Cooper, it's just fallen down here. They just didn't carry their clear and convincing burden of proof. The record clearly justifies that. On the options, the evidence on the options, I want to talk about that a little bit, and then I'll ultimately get to what Phil talked about here. The evidence on the options, Rymuth agreed with the judge. The judge accepted Rymuth's testimony on that. And if you'll recall, we covered this in our brief, at the arbitration hearing, the husband acknowledged that the figures that he was advocating and the allocations that he was requesting were based on Rymuth's calculations. And then after Rymuth gets up there, says what he says about the options, husband himself decides, oops, I'm going to say something different. And that's where he came up with these charts and these ideas that he personally had. Well, he's not qualified to give those as an expert to begin with. But nonetheless, the ultimate question for the court, if it reaches the merits, is did Judge Budoff abuse his discretion or err, I guess, by picking Rymuth's testimony over husband's? And, you know, this is the typical he said, she said, only instead of the parties arguing, it's him arguing with his own expert. And I don't think we can there's any provision in the law that allows, when there's clear evidence, express evidence from the party's own expert, that the trial court was wrong in accepting it. That's only as to the options themselves, which comes out to a big amount of money. Particularly the 2,000 option. I think that was 32,000 shares of stock, which was a lot of dough back then, probably still is. The bigger question is they're arguing about this collateral account. And the collateral account, the basis of their argument, and although Phil didn't talk about it here, they talk about it a lot in their opening and reply brief, that we conceded that the collateral account was all husband's dough. And if you actually go, it's, you know, I hate to keep going back to the record here, but if you actually look at the joint pretrial statement where that concession was allegedly made, and the sole exclusive basis for their argument that we conceded this, they leave out the footnote. They forget to tell the court that the footnote says this is currently being reviewed. And by the time we get to the arbitration a week or 2 weeks later, it's very clear that it's not it's not sole and separate money, because at the time that the collateral account was funded and then stock price fell, and then they had to slide some more money or slide some more shares over to secure this margin account a few months later. At that time, there were 11,685 shares, community shares, in the primary account. And they're saying, well, since there wasn't enough to slide it all over, we're not going to slide any of it. It's all going to be considered to be his sole and separate. The problem with that theory, and this is it's almost comical, that the one thing they could the one thing they could explicitly trace was a subsequent sale out of the collateral account, and it was part of the 2,000 options, which were deemed to be community property due to commingling. So we know for a objective fact in the evidence that there were community shares in the collateral account. commingled, of course, with all of the other commingled shares, so you couldn't distinguish between the two. And this is where Phil's pot-off argument falls down. We're talking about fungible goods here. We're talking, it's not money, cash money, but it's stock. I mean, we have lots of shares of stock that came in at different times, at different values. You can't distinguish between any of them. This is not like Blackacre and Whiteacre, where you can't combine them to make Grayacre. And it's not a 68 Shelby Mustang that retains its thing, or a Picasso painting that you can always trace, which maybe if it were, we could give some credibility to the pot-off analogy that he should get the Mustang or whatever, and she'd get a equitable lien for the community interest. This is all in one big pot, which is the whole problem with this whole case. It all gets back to commingling. And Mr. Sue testified at trial. He made all these decisions. He made the calls. He made no effort to segregate the sole and separate property. When he exercised these options, when he funded the collateral account, when stocks were sold, no effort to segregate. And that's fine. I mean, we all like to be masters of our own fate, as it were. But there are ramifications for that. We all have to keep our IRA money separate from our other retirement money for tax purposes. But here, they had to be kept separate for allocation purposes. And yeah, I'm sure, my guess is, he wasn't expecting that 11 years later we're going to be going through a divorce, but things happen. And the problem here was created by himself, because he's the one that made the decisions and ultimately allowed all these things to be commingled. That's pretty much all I've got. I think we went on the merits, but I really don't think you get to the merits at all because of both the language of the contract and, more importantly, subsection 3004, subsection C. Thank you very much.
Thank you, counsel.
Let me deal briefly with the arbitration issue. Page 10 of our reply brief lays it all out. Arizona's version of the revised Uniform Arbitration Act does not prohibit parties from negotiating the range of appeal. The committee that dealt with it reviewed opt-in clauses, which of course is the creating substantive merits appeal jurisdiction, and stated that, quote, parties remain free to agree to contractual provisions for judicial review of challenged awards on whatever grounds and based on whatever standards they deem appropriate until the courts determine the propriety of such clauses, citing the uniform law as annotated. So there is nothing in Arizona law that says you can't do what these people agreed to.
What about the statute that counsel cited, 3004 sub C, which says that the parties may not waive or vary the review, several statutes, including 3023?
Which is not anything that precludes what we did. In fact, there's this other subset of the challenges in this case where they claimed after the award was being, when we filed our 3020 motion, which is permitted both in the arbitrator, it's like in the trial court context where you're saying, please correct this because it's wrong, and then we're going to appeal. And they said, no, you can't change anything. Well, obviously, the 3020 says you can change things, omitted issues, which is the classic example of what happened here. So there's nothing that says you can't, in Arizona, in that statutory context, do this. In fact, the commentaries have said exactly what we're reading. Apparently, you don't.
Well, I read here in 3004C states that the parties to an agreement may not waive or vary the effect of a number of statutes, including 3023, which is the section that says that the court shall vacate an award on certain specific grounds not applicable here.
Well, but even if that's the case, which I don't believe that that's the correct interpretation of that, but then you end up with the question that Judge Winthrop had, which is the parties agreed that the issues would be decided according to Arizona law, Title 25. They obviously weren't. I mean, when you're listening to the factual presentation here, you start with the very first thing that is wrong. When he says there's 2,000 Intel shares here, which turned into the 8 that were sold. Well, there's never 2,000 Intel shares in this account that if you decide the first issue correctly, which is Potoff and the, even their cited cases. The only Intel shares ever in this account are the ESPPs. That would be the classic de minimis argument in Arizona commingling law. So if you don't decide the case according to Title 25 in Arizona interpretive law, you've exceeded your authority. This isn't some situation where people are saying, oh no, we don't care how you decide your case, just decide it. And then we'll be done. Why would people preserve an appeal? Turning to one other thing, they make, or two other things. They attempt to make a big point of our suggestion that somehow they conceded us in the pretrial statement. Well, it's better than that. They admitted it during the trial examination. Obviously, you've read these specific pages, but if there's anything more to be read in this thing, please reread pages 27, 28, 38, 41 of our opening brief, and pages 16 and 17 of our reply brief. The 27 and 28 and 16 and 17 are the verbatim transcripts where wife's expert admits that all 205,000 that's left, she used an approximate number, are his separate property because she recognized that there was no ability to have any Intel shares in this account that were community because of the fully vested options before marriage, and that no shares, Intel shares, were ever acquired during the marriage that would be community. Again, other than the little ESPPs. So when she's admitting this isn't some pretrial concession. This is a stipulated, or not a stipulated, this is a cross-examination concession during trial. And then, most importantly, with respect to the legal issues, and the reason I asked you to look at pages 38 and 39, there's much that's being made in this case of the Cooper case, and the limited amount of facts in that case are a savings account, not a brokerage account. That's why I said earlier, all these Arizona cases about commingling are dealing with cash. Stevenson is...
If you want to wrap it up, your time is up. If you want to wrap it up, though.
Okay, Stevenson obviously says, and it's decided after Cooper, it's the Supreme Court, it's the year after, and it's citing the Title 14 statute. So that is the tracing standard in this state. The statutes direct us what's supposed to do, and nothing in 25.318 says that the court, when it's tracing separate property, is supposed to find some connect the dot or blue nickel approach. Thank you.
Thank you both very much for your arguments. We will take the matter under advisement and issue a ruling in due course. And with that, we are adjourned.